All right, here we go, folks. The U.S. Supreme Court closing the term today with two major cases. You can hear the noise on the steps of the Supreme Court this morning as the emotion is building outside. We're going to be getting those decisions any minute now. Welcome, everybody. Brand new hour of America's Newsroom. I'm Martha McCallum.
Hello, Martha. I'm Eric Shawn in for Bill Hemmer this morning. First case is the Hobby Lobby case that addresses the issue of birth control mandate in Obamacare. And the other big case affects public employee labor unions, the court deciding whether non-union workers can be forced to pay union dues. We have Teen Fox coverage. Shannon Bream is out in front waiting for word on both cases. Our senior political analyst, Britt Hume, is standing by in Washington. And senior judicial analyst, Judge Andrew Napolitano, is here in the studio in New York. But we'll begin with Shannon Bream, who is waiting outside for these potentially historic opinions any moment now. Hi, Shannon.
Hi, Eric. Well, as you can hear, probably there are large groups of protesters on both sides of this issue. They're primarily here for the Hobby Lobby case. But the fact is they've been chanting for the better part of an hour. In just seconds, our runner will come down those steps. We'll have the opinions in hand, and we'll know what we're dealing with here, win or loss for the government or for Hobby Lobby. And in the other case, the Harris case you mentioned, it essentially boils down to whether a state can force home health care workers into a union. I suspect that the Hobby Lobby case is going to steal all the thunder on an opinion day like today, but they come at 10 o'clock straight up. We're waiting now to see which one comes first. My prediction would be, a guess here, would be that we get Harris, the union decision first, and we'll have to wait for Hobby Lobby, but we'll know in a matter of seconds or minutes. We'll come back to you as soon as we get the opinions, Eric.
All right, Shannon, thank you so much. Martha?
All right, so as we wait here this morning, we should remember that this court has surprised everyone before when it comes to the issue of Obamacare. It was 2 years ago when the president's health care law faced a major challenge to the individual mandate, and it came down to whether it was a tax or a fine if you decided to opt out of the Obamacare health care mandate. And it came down to Chief Justice John Roberts, who really surprised a lot of people when he cast the pivotal vote that preserved the mandate. Britt Hume is Fox News senior political analyst. Britt, good morning to you.
Good morning, Martha.
It's really, so much to talk about here in terms of the religious liberties and the religious rights of corporations, and also Chief Justice John Roberts and his role in all of this. So let's start with the issue that is at stake and whether or not profit companies have a religious right.
Well, it seems to me, Martha, that the court has some options here. What I think, the people who are watching this, who are on the side of religious freedom, would like a sweeping ruling that says that, yes, corporations and everyone else have a right of religious freedom, which would be extended, not providing birth control coverage to their employees. But remember this about these two cases. There are two companies involved, Hobby Lobby and one other. They don't object to providing most forms of birth control. They only object to a couple of forms which they think amount in effect to abortion. So the court could make a narrow finding that says that companies whose religious beliefs are unmistakably part of the fabric and the culture of the companies would have a right to opt out of these few provisions. That would be the kind of narrow ruling that this court has liked in the past. Of course, it could uphold the government's view and say, sorry, you're a profit-making company. The religious sentiments of your proprietors don't apply here. You got to provide it. That's obviously another option. And, of course, the third would be a big sweeping ruling that blows away the whole contraception mandate. I kind of don't expect that, though, Martha. I think they'll either uphold it or they'll give us a narrowly tailored exception to it for companies whose religious beliefs are part of their fabric.
As I said, a lot of people are going to be watching Chief Justice Roberts on this closely. There's some discussion that he may be the one to write the opinion on this because they sort of distribute the opinion writing throughout the court, and it's kind of his turn. But it's also not lost on anybody that he came under a lot of heat for his decision from conservatives when the Obamacare mandate decision came down. And this could potentially be an opportunity for him to change his thoughts on this whole thing to some extent.
It could. Let's remember that what he basically did when he upheld the individual mandate was they blew it away in part, but he upheld it as in effect, a tax break. In other words, instead of it being seen as a fine if you don't comply with the individual mandate, he said, no, you just have to pay more in taxes, that you get a tax break if you do comply. Of course, the net effect of it in many circumstances would be the same thing. But it meant that the Commerce Clause, which has been used by the court to get into areas that no one ever imagined that the government would be allowed to get into, was not upheld as a way of doing this mandate. So Roberts has shown some creativity in finding ways to thread the needle between one side and the other, and they may do that here.
They may. We just want to point out that a decision has come through in the Harris case. It's being read at the moment, so we'll start to report on that as we digest it. Where are we going to go right now? All right, we're going to go to Shannon Bream outside the Supreme Court. Britt, thank you very much. Shannon, what do we know so far?
Martha, we have two really important things we already know. First of all, we have the Harris decision, and this dealt with people who are home health care workers. A lot of them care for disabled children or disabled relatives in their home. The state of Illinois wanted to force them into a union. What the court has said basically here is that the First Amendment prohibits the collection of an agency fee from personal assistants in the rehabilitation program who do not want to join or support the union. So these family members who are fighting to just be able to stay home, take the government payments, rather than institutionalize their relatives. They want to stay home and care for them. They didn't want to be forced into a union that would take a bit of the fee off the top and take a bit of that money away from them. And they said, the union doesn't speak for me. I want nothing to do with them. Here in this case, written by Justice Alito, a 5-4 opinion, the First Amendment prohibits forcing them to pay those union fees if they want nothing to do with the union. Now, something very critical to watch. When they announce the opinions from the bench, the Chief Justice says, with our opinion in Harris v. Quinn, for example, here, Justice Alito, he reads the opinion. What he said today was with the first of two opinions. So we know now that Justice Samuel Alito has written both opinions, meaning he wrote the Hobby Lobby opinion. We know that for sure. We're going to have to wait to get it. That could tell us a lot. He was very critical of the government's arguments during the oral arguments here at the court. So you can take that one way or another. We're reading a bit of tea leaves, but we do know now for sure that Justice Alito has written both the opinions today, including the Hobby Lobby opinion that we'll get any minute.
Well, that's fascinating, because we were just talking about the fact that a lot of people thought that Justice Roberts might put the Hobby Lobby decision out and might have an opportunity to sort of further clarify his feelings on Obamacare, at least through the purview of this decision. Shannon, stand by. Obviously, we're going to be coming back to you with more in the breaking news. I want to go to Judge Napolitano and get his reaction first to this union case. What does this mean for them, Judge?
Well, this doesn't quite gut the public unions in the United States of America, as some of the people watching this case had hoped, but it is a substantial setback for them. It's a setback for state legislatures, the more liberal or progressive state legislatures, that want to force people to join public unions because they can no longer require them to pay dues. If they can't require them to pay dues, then there's no advantage to forcing them to do so. May I also say that I can't help but jumping in on the fact that Justice Alito has written this opinion as well as the next one. On this one, Justice Alito has been the leader on the court in restraining public employee unions. So without having seen it yet, and it's on its way into the studio for me to look at, this is probably about as forceful an opinion against public employee unions as you can get. Secondly, the fact that the Chief Justice has announced that Justice Alito has written the Hobby Lobby decision almost certainly means that the government has lost. Again, we have to read it, and again, we have to hear at least the initial words coming out of his mouth, but it is inconceivable that he would have written an opinion supporting the government on that.
Yeah, very interesting. Now, just to the union case for a moment, it used to be, there was a precedent, I guess, in 1977, a Bood case I was reading about this morning, which basically said even if you opt out of the union and you don't want to be part of its political activity, if you benefit from what the union gets for you in terms of an employment and compensation package, then you've also got to pay us dues. So is that a precedent-setting decision in regard to all of those arrangements?
Well, again, begging the question a little bit because I'd have to read it, but it does appear, and I haven't gotten it yet, but it does appear from the snippets of information we're getting from our colleagues who are quickly reading it in in that building that you see on the screen, as well as from the various blogs that are coming in, it does appear as though the Supreme Court has not overruled that Abood opinion, but it's put a backstop on it, saying we're rethinking the issue. You now no longer not only have to contribute politically to these union coffers when you disagree with their politics, you don't even have to contribute to their operating accounts if you don't want to be a member, because the First Amendment to the United States Constitution, which guarantees freedom of speech and freedom of worship, etc., also guarantees freedom of association. And freedom of association, the right to join any group you want, also prohibits the government from forcing you to associate with a group that you don't want to join. And here, that would be the labor union.
So we're waiting for the second opinion here, which we have already learned, according to Shannon Bream, will be written by Justice Alito. If it had been written by Justice Roberts, would you withhold your judgment about which way this went? Because certainly he surprised everybody 2 years ago with his health care decision, Judge.
Yes. Personally, if I learned that the Chief Justice had written this opinion, my heart would be in my stomach. But professionally, I would have held back any judgment on it because of the creative way in which he saved Obamacare 2 years ago. But it appears that just as the Quinn case, the labor union case, was 5-4, the 5 conservatives prevailing, the 4 liberals dissenting, it appears that that will most likely be, again, we haven't seen it yet, we haven't heard a word out of Justice Alito's mouth on it yet. It appears that that will be the same breakdown in the Hobby Lobby case as well. It
also tells us, though, that Justice Roberts did not want to take this opportunity for himself to talk about Hobby Lobby.
I think that Justice Roberts was chastened by the overwhelming reaction of some of his closest friends and strongest supporters to the creative way in which he crafted the majority opinion in the Obamacare case. The technical name of it is Sebelius. I'm not going to suggest that that motivates people. He's got a lifetime appointment, but he is a human being, and he is aware of where all this is going.
You know, it strikes me that this court has an opportunity in this Hobby Lobby case to make some larger potential comments on how all of this affects whether or not a corporation is a person, so to speak. And we're going to touch on that in just a moment. Judge, we're going to take a quick break here as we wait for the Hobby Lobby decision to come in, and we will be right back with more.
Look at the apparent setback to the public unions. The woman who brought that case, Pamela Harris, watching right now. We will get her reaction live to this potentially groundbreaking decision against public unions.
Here's that